If you bring a lawsuit for medical malpractice against a doctor whom you once loved, is the doctor going to lose his license? You want to know the answer? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The short answer is no. The doctor is not going to lose his license if you bring a civil lawsuit seeking money as a form of compensation for all of the harms and losses and damages that you incurred as a result of the doctor's carelessness. Now, let me go back for a second. When you believe you have a valid case, you reach out to the best attorney you can find, and now the attorney does a detailed and thorough investigation by getting all of your medical records, reviewing every page of those records, and then sending it out to a qualified medical expert to comment and evaluate whether the treatment you received was appropriate. If the medical expert comes back and determines that yes, your doctor violated the basic standards of medical care, meaning that there was negligence, there was carelessness, the next question the expert has to answer is whether that doctor's carelessness was a cause of your injury. It doesn't have to be the cause, it only has to be a cause. If the answer is yes, then we look to see what type of injuries and damages and limitations and disabilities you have as a result of the doctor's wrongdoing. Only if our medical expert confirms each one of those things, that there was wrongdoing, that the doctor's wrongdoing was a cause of your injury, and that your injuries are significant and or permanent, only then are we permitted to go forward and bring a lawsuit on your behalf. Now, a lot of people think that if they go ahead and bring a lawsuit, it's going to accomplish two things. The prevailing mindset by a lot of injured victims is that by bringing a lawsuit, not only will they obtain money as a form of compensation for their injuries, but at the same time, they will also force the doctor to lose his license to practice medicine. The reality is that is not the case. The first part is true. Yes, these lawsuits are solely designed to try and obtain money as compensation for all of your injuries. The second part is not true, meaning it is not designed to get the doctor to lose his license. These are civil lawsuits involving negligence and medical malpractice. That has nothing to do with whether or not the New York State Department of Health determines that the doctor is an imminent danger to the general public here in New York. If by some chance the doctor's actions rise to that level, where the doctor's actions that he has taken in the past and the potential to take in the future rise to the level of such imminent danger, the New York State Department of Health in that instance would independently determine that this doctor is not fit to practice medicine, and as a result of that, they would likely immediately suspend his license and have additional hearings to determine whether or not this doctor should have his license revoked either immediately or sometime in the near future. So those are two separate independent things. Many people turn around and say, okay, if they're two separate things, can we go forward with a lawsuit and at the same time go ahead and start proceedings with the New York State Department of Health? The answer is yes and no. So let me tell you what I mean. If you file a complaint with the New York State Department of Health about the doctor's actions and his improper activity and his improper treatment of you, that will typically generate an investigation into the doctor's actions. Now, if the doctor has been investigated before by the New York State Department of Health because of other patients who have complained about the care and treatment they have received, they will look at the other complaints, they will look at your complaint, and after reaching conclusions about your investigation and reaching conclusions about the other complaints that were generated by other patients, they will come to their own conclusion about whether or not this simply is a matter of negligence, the doctor was careless at various times during his career, or whether this represents a significant pattern and now creates an imminent danger. And I use those words because they are important. They're important in determining whether or not the doctor's license may be suspended or be revoked. There have been some instances where the New York State Department of Health has determined that a physician is an imminent danger to the general public. And I'll give you two quick examples. Many years ago, I was representing a woman in a plastic surgery case, and she sued her plastic surgeon because he totally botched the procedures. My client filed a very detailed complaint with the New York State Department of Health, and during her investigation, we learned that many other patients of this particular plastic surgeon had also filed complaints with the New York State Department of Health. During the course of my client's lawsuit, we received notification from the New York State Department of Health that this doctor's license was being revoked immediately. Immediately. Why? Because they determined that he was in fact an imminent danger to the general public. And they could no longer allow this doctor to continue practicing based upon the many, many proven complaints by these various patients, as well as my client's complaint about the botched nature of her particular injuries. So as a result of the New York State Department of Health's investigation, they concluded that this doctor's license needed to be revoked. Did it affect our case? Absolutely it did, favorably. Why? Because we knew at that point that the defense could never, ever defend this case successfully at trial. So another instance where the Department of Health actually revoked the doctor's license was a very bizarre situation. It involved a surgeon who had performed abdominal surgery on a patient at a hospital in New York City. And during the course of surgery, this doctor decided to leave an indelible mark inside the patient's abdomen. And how did he do that? Not with a Sharpie, not with a permanent magic marker, but by carving his initials on the patient's inside abdomen, on the interior part of her abdomen. That's how he did it. And when the Department of Health learned this information through their own investigation, they realized that this is outrageous behavior by any surgeon, and this would not be acceptable or tolerated under any circumstances. And it turns out that the Department of Health did in fact immediately revoke that doctor's license to practice medicine. And we later learned through news reports that this doctor had a history of mental illness, which might have explained why he did something as bizarre as carving his initials on a patient's abdomen during the course of surgery. So in that instance, they clearly revoked his license to practice medicine. But the entire goal and the entire purpose of bringing a lawsuit is not to have the doctor's license revoked. It is not to destroy their reputation. Their goal primarily is to go ahead and obtain money as a form of compensation for all of the harms and losses and damages that you, the injured patient, suffered because of the doctor's carelessness. So why do I share this quick information with you? I share it with you just to open your eyes and help you understand how these types of cases work here in New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.